We are live. Jonathan, we are live.
All right. Good evening, everybody, and welcome to this webinar on mediation. My name is Jonathan. Catching a bit of an echo, if that can be fixed. Thank you so much. My name is Jonathan Rodriguez. I'm a certified mediator. I have a background in psychology and law. I'm currently based in a workplace mediation firm that is headquartered in London in the UK, but very much in Goa right now, very much experiencing the unprecedented monsoon in Goa. After a long time, it feels like my childhood all over again. So yeah, great to have all of you joining us today. This is a special day for a few of us who have, of course, been part of the Nirmala Institute Education. This is, of course, the Diamond Jubilee year, and all of you know that the Nirmala Institute of Education is a premier teacher training establishment based in Goa, and they're one of the co-organizers. They're one of the co-organizers today for this particular webinar. It's also the foundation day for the sisters, the Society of the Daughters of the Heart of Mary, who had established this institute in 1963 when there was an urgent need for trained teachers in Goa. So big shout out to Nirmala Institute of Education helping us put together this webinar. The other co-organizers, of course, are Pedro Arrupe Institute. It's a Center for Ignatian Spirituality, of course, run by the Society of Jesus of the Goa province. It offers retreats and courses on spirituality, scripture, and theology. So if you have not yet visited the campus in Raya, I suggest you go and do so. It has a sprawling campus, and you would, if you're feeling really stressed about what you're doing in life and you just want to relax, that's the place to be. And you can reach out to Father Felix, who is based there. And of course, a big thank you to Dr. Rita Pace, who's the director at NIE, for helping us put this together. A lot of more thank yous to come, but I'm very eager to get started on this particular session. I got two very eminent gentlemen with me, and some of you are already familiar with the work that they've done in Goa. And if I start reading out their CVs, we'll probably finish way past dinner time. So I'm going to keep it really short and yet try and be, do justice to their CVs. Let me start off with Justice Nelson Brito. He joined the judicial service as a civil judge in 1982, was appointed as additional district and assistant sessions judge in 1994. He was then appointed as a district and sessions judge in 1997, and a post he held until he was appointed as a judge of the High Court later on. He was also the former president of the Goa State Commission, and post his retirement, of course, is a retired justice now. He serves as an arbitrator and a mediator through his private practice. Justice Nelson Brito, thank you so much for joining us. Also want to introduce to you our second guest, Judge Desmond Da Costa. Of course, he was appointed as a civil judge in 1992. He was then promoted to senior division in 1998 and was appointed as a district and sessions judge 4 years later. In 2016, he was appointed as a principal district and sessions judge. He was also a special judge of the Narcotic Drugs and Psychotropic Substances Court in Mapsa. He is currently a member of the Goa Human Rights Commission. And all of you must be wondering, why did I invite two very eminent judges to talk to you about mediation? And let's try and get their initial thoughts about what mediation is. I know the title of our webinar is, are you willing to settle your civil and family disputes and personal disputes and property disputes out of court? Can you do that, first of all? And once, I'm sure they're going to convince you that you can do that today. And maybe we'll spend the second half of today's session talking to you about how you can do that. And if you feel like you're the only one who wants to do that and the other side is willing, we'll also try and address that concern. But handing it over straight off to Justice Nelson Brito for his initial thoughts on this topic. So.
Good evening, everybody. Why are we talking about this mediation? Has our judicial system collapsed? We must know a little history about this. One thing we all agree, whether it is judges, lawyers or litigating public that our judicial system suffers from three ills and there are no pills. One, delay in disposal of cases. Two, high cost of litigation. And three, results which are very often unpredictable. Chief Justice Warren Burger would say, legal problems, like people in pain, want relief and they want it quickly and as inexpensively as possible. If the system is left to itself, it is bound to collapse sooner or later. Just the other day, on 15th instant to be precise, the Legislative Assembly was informed that there are more than 57,000 cases pending in various courts in Goa. And as far as India is concerned, someone said that in case the case files of our cases are stacked one on top of the other, the pile would be taller than Mount Everest. On 16th instant, again, the Honorable Law Minister Rijiju has informed the nation that there are 5 crores of cases pending. Although we have one Supreme Court, a famous lawyer said that its decisions tend to pull in different directions. And as Justice B.N. Shri Krishna would say, our judicial system is like an old ambassador car. It rattles, creaks, but it still operates. But when it reaches, when will it reach destination, if at all it reaches, and whether it will reach in one's lifetime, we do not know. If there are delays in deciding cases, and whatever may be the reason, whether too few judges, or delay in appointment of judges, or too many cases, our search to find alternate solution to the problem, including mediation, also bogged down in delays. Parliament enacted the Legal Services Authorities Act in the year 1987. And one of the aims of the act was to give recognition to our old institution of Lok Adalats. You will remember in the villages, the cases would be settled by what is known by the elders of the village, known as Dhazan. The second aim of the act was to give legal aid to the weaker sections of the society. The second attempt made by Parliament was to amend Section 89 of the Civil Procedure Code, and this was in the year 1999, with a view to provide settlement of cases by mediation, and that is what we are talking about today, conciliation, arbitration, and Lok Adalats. In that year, I had the privilege of becoming the only judge trained, certified, and accredited as mediator. But then again, Section 89 took 3 more years to be implemented. It came to be implemented only in the year 2002. In that year, I set up a counseling and consultation center at Margaon, all of my own, in my capacity as the chairman of the South Goa District Authority. It was the first of its kind in Goa as well as in Maharashtra. And to save my own skin, I got it inaugurated by none other than Justice P.V. Hardas of the Bombay High Court. We nominated social workers and experienced lawyers. Together with those lawyers and social workers, the center did excellent work in settling all sorts of disputes between parties, both pre-litigation and post-litigation. 2 names which readily come to my mind and who helped us in settling the cases are Advocate S.N. Karmali and Advocate B.F. D'Souza. They are no more amongst us. I distinctly remember a case where I was hearing anticipatory bail application. I referred the parties and the police officer to the center. They call all parties involved. Talk to them. The dispute was settled. On the third day, the applications were withdrawn. Courts are also required to endeavor to settle family disputes in terms of Order 32A of the Civil Procedure Code. That nobody makes use of this provision is another matter. In making use of this provision, we enlisted the services provided by Diocesan Family Center, lady mediators available with Women's Commission, and others. There is no dearth of trained mediators today. The great have always exhorted us to settle our disputes by compromise. In Matthew chapter 5, verse 25, Jesus says, if someone brings a lawsuit against you and takes you to court, settle the dispute with him while there is still time before you get to court. Abraham Lincoln exhorted to discourage litigation and to persuade your neighbors to compromise whenever you can, pointing out to them how the nominal winner is often a real loser in fees, expenses, and waste of time. As a peacemaker, he said, the lawyer has superior opportunity to be a good man. There will be business enough. Our own Gandhiji said that during the 20 years of his practice as a lawyer, he was occupied in bringing about private compromises in thousands of cases, and that he lost nothing, not even money, and not his soul. Now, what is this mediation? Mediation is a tool used in the settlement of disputes. Mediation is a structured process by which disputing parties engage the assistance of a neutral third party to act as a mediator, a facilitating intermediary who has no authority to make a binding decision, but who uses various skills and techniques to help the parties resolve their disputes by negotiated settlement or agreement. What is required in mediation? 1, a will to talk. I repeat that, a will to talk to your opponent. Number 2, an attitude to give and take. Again, I repeat, an attitude to give and take. In mediation, there are no losers. Both parties are winners. A famous example is a dispute about an orange. Two parties were fighting over it, but their motives were different. In the course of mediation, it came to light that one party wanted the whole of orange for its juice, and the other wanted it for its peel. It is only after talking to both the parties that the mediator was able to satisfy both the parties, giving one party the juice and the other party the peel. And both parties went happy. That is an old saying. It is better to have loved and lost rather than not to have loved at all. Likewise, I would say, it is better to have tried mediation and failed rather than not tried at all. Over to Jonathan.
Wow, I never heard that phrase being used in a mediation context. Thank you so much, Justice Nelson. I'm going to steal that from you and use it further. But thank you so much for that really well articulated introductory remarks about, in fact, also throwing light on some of the history of the mediation movement back in Goa, which some of it I was not aware of myself. But of course, from your lens, and I'm sure there's so much that Judge Desmond would also like to share. But I just want to take a step back here because Justice Nelson has given us a very elaborate idea of what the scenario of mediation is right now in India. And today we're talking about, are you willing to settle your family and property disputes in Goa? And why we're doing that? Because both the Nirmala Institute of Education based in Altino in Panjim and Pedro Arupe Institute based in Raya are coming together to put together a center for mediation and reconciliation. and they're working in the background as we speak to make that happen over the next few weeks. And we hope that this center will help the community, help people from all faiths and all backgrounds to come together and resolve disputes that are a pain for themselves. And Justice Brito has already highlighted a few examples of why mediation makes sense. And I like what he said there. One of the things is the will to talk. And let me just spend 30 seconds more before I bring Judge Desmond in on the will to talk and the fact that it is a voluntary process. It will always remain a voluntary process because you have the choice to say no to the person who's inviting you to mediation. So if say there are two neighbors who are in a dispute over a land issue, and if one neighbor says that, let's try and sort this out, let's invite a trained mediator to help us sort this out, who also understands the law maybe. And the other neighbor says, no, I don't want to do this. You can't force the person to come to the table. But as mediators, we have different ways to try and convince the other person to come to the table, and we'll come back to that a little later. But it will always remain a voluntary process. And for a lot of people who have that question, can you be forced to mediate? No, you can't. But judges do have a very, very big role that they can play when they see a case maybe on their table, in their courtroom, and they look at that case, they're reading the case, and they realize this is not worth my time. I mean, I should be spending my time on something that's more, that requires more of my wisdom and thinking and logic to resolve this, to settle this dispute through a judgment. This can be easily resolved. So, throwing this question straight out to you, Judge Desmond, have in your career as a judge, you probably have come across a lot of those kind of cases. They were like, why is this in my courtroom? And could you throw some light on, of course, examples like that where you thought this case was much better suited if both parties just sat together, found someone to help them to talk and resolve through mediation? You'll have to unmute yourself.
Good evening, everybody. Justice Brito has put it very aptly, and in fact, he was our guide and our philosopher always. Though we say that Goenkaram is Susegad, so it's like Goans are very relaxed, and Goans are very, also, as Justice Brito pointed out, figures of 15 July disclosed in the Goa Assembly was that 57,000 cases and order pending in the Goa courts, which means it's a very big amount of cases. And in fact, as you said, many of the cases which come to courts are cases which should be resolved at the earliest. Because the longer the litigation goes, there's a saying in Konkani, Kotan Payan Dorop, the kid, Sarki Kabar Kortam. I mean, it's like a worm which will destroy the family. And that is why, like everybody, in fact, we have always been, as judges, our duty is to hear both the parties and to give our judgments. That is our primary role. Because we have to see between who is right and who is wrong. But due to as pointed out by Justice Brito, the legal system in our country, the wheels of justice are totally clogged. Means the wheels are not moving ahead. There are so many crores of cases pending in the rest of the country, in subordinate courts, even in the high courts, and even in the Supreme Court. And the best way out, in fact, is like, as the world has taught us recently, is mediation. And that is why I feel that, in fact, Goans, we feel that, this is a way that people come to the courts. But many times, like we have seen that when we try to resort to conciliation, mediation, when we talk to the parties, many disputes do get resolved. And parties, in fact, one of the queries which you had raised was that both the parties go out happily. That is the way we want people to be happy. Because that is the only way, in fact, which justice can really be done in the society. Thank you.
Thank you, Judge. Desmond, I have feel a bit of an echo, actually. All right, that's taken care of. Yeah, so I think just once again, thank you so much for articulately putting that and advocating for mediation as someone who has seen that firsthand, where you thought there was a case in front of you that did not require to go through the entire timeline of a civil case. And the little math that I did before I did a TEDx talk on this was, it taught me that the normal lifespan of a civil court case in India is somewhere between 10 and 12 years. And I mean, you're lucky, that's an average. Sometimes we have cases where a great grandfather has filed a case and the great grandson is still fighting the case. And I'm sure you have come across many of those kind of cases. And the point is that a lot of people who I speak to say they were not aware that something like mediation exists. And what are the values of mediation? So just to kind of quickly focus on the values of mediation. And we talked about a few principles already. We spoke about the voluntary nature of mediation, the fact that you cannot force someone to settle. You cannot force someone to even participate. And the key word is invite. You have to invite the other side to the table, invite the other side to a dialogue. So that's very crucial. Secondly, it's confidential. A lot of family dispute, a lot of property disputes, you don't want to be washing your dirty linen in public in the courtroom, right? Who's attending the courts besides you and the other side? There are other lawyers, there are other people, of course, who have come for their own cases. There's the media, there are your nosy neighbors who come to see what's happening in your family life. Let's go and check out their court case tomorrow. You don't know who's there. So mediation provides you that private space where you can sit down with the other person, maybe with your lawyer, with the other person's lawyer, and with a trained, certified mediator who can help you resolve disputes confidentially, privately. Now, the problem is the moment you say the word private, people start thinking this is some illegal, under the table side business deal going on. It's not. I know as Goans, we are so, it's part of our lives in a way that every day in the news, especially these days, we're reading a lot about under the table deals, but let's not go there. The point is that just because it's private, it does not mean it's under the table. It's absolutely a legal process. It is, as Justice Brito has already told you about the different laws that recognize it. It's absolutely a legal process, but it is, of course, a confidential process. The third very important thing about mediation is it's the fact that it's self-determined. The parties make the decision. And the great example that once again Justice Brito gave about the Orient story, it's the parties who decided what was good for them. One of them wanted the juice, the other one wanted the peel. So it's the parties who make the decisions, and it's much better than a stranger, a very competent stranger, of course, being a judge sitting in court deciding who's right and who's wrong. But if you want to go to a place where you don't want to decide who's right and who's wrong, but you want to make amends and you want to find solutions and move ahead, then of course mediation is your thing. Now, that having said that, not every case can be mediated. You cannot mediate criminal cases like rape and murder, but you can of course mediate the criminal cases which are, say, smaller importance, in a way, like you can take care of, say, motor vehicle disputes. You can compoundable disputes. Thank you so much. I needed the professor to step in. I got a bit of a brain fog there. Yeah. So cases that can be disputed where there is no harm to, of course, the person involved are, of course, mediatable. And there are a lot of changes already taking place in this scene. But quickly to bring it back to the topic of, a lot of people might be willing to mediate, but at the end of the day, they do not come to the table. They do not want to, sit across the table with the person who they've built up so much animosity and anger for. So from a very psychological people perspective, question to both my guests today is, why do you think it's tough to even explore the idea of mediation for two people who are in a dispute? For them to even consider the idea of sitting across and resolving dispute. Why do you think they find it tough to even contemplate something like that? Justice Brito, would you like to go first? I think you muted yourself by mistake.
Yeah, there was a time, if you suggested to the parties any compromise, conciliation, or mediation, the parties would suspect the motives of the judge. There were such times initially, but today that does not happen. Now, as I have already said, to me, except serious criminal cases, if the parties are willing to talk, every case can go for mediation. I'm of firm view. But I do think that it requires certain amount of education for rather educated litigants. so that they know where they are going to save and where they are going to spend. Sometimes spending after lawyers is more than they would get from a settlement. To repeat, I would say that every case can be mediated, as I have already told, the parties must be willing. Many of the misunderstandings are because the parties don't talk to one another. And after you start talking, you know where exactly the differences are. And as I have already said again, little give and take is absolutely necessary.
Absolutely. Justice Desmond, Judge Desmond, would you like to add to that? I think you're on mute, Judge Desmond.
Yeah, what I was trying to say is that when people come to courts, they have great confidence in the courts because they feel that courts are next to God. Like we know that God can do no wrong. Like, and justice, we say, is always blindfolded. So people feel that the judges, especially like the Goa has got a rich background with some positive, what do you say, like advantages of the Portuguese judicial legal system that was operating in Goa. Like people had great respect for judges and for advocates because they used to report to them respectfully as Dotor, because there is like it shows like the attitude which Goan people had towards advocates and judges. It means everybody used to call Dotor. Dotor, and we used to say Botsan Fator. Means because there is a joke that was made, because many times like advocates and used to not guide the parties properly. So many litigants, in fact, initially want to approach the court because they say that let us file it in court. We'll see later. And when you say like when the anger is boiling, like means the people are really, the disputes are reached a breaking point. Like instead of breaking each other's head, the best thing is to go to the court and try to resolve it. And in Goa, we know, like in Goa, most disputes are like civil disputes are rising from property disputes, which then end up in criminal litigation, because when the property disputes are not being resolved, parties end up attacking each other. And like most of the Goan litigation basically is relating around property. And we hardly have much corporate now of late with the industrial development that is taking place in small scale industries coming, and some amount of corporate law is also coming into the field. But otherwise, people, I think that in the first instance, like even earlier, prior to the enactment of the amendments in the CPC, there was hardly the concept of pre-litigation. But now pre-litigation has become part, and mediation, the message of mediation is now spread far and wide. But I still feel that we have a long way to go. Like means what they say, like that it's a bright light in the tunnel, but the tunnel is still dark, and people are still, they do not know what is mediation. And I think that trained mediators and great experts like you can play a great role in spreading this message. Yes.
Thank you, Judge Desmond. I think so. Yeah. Thanks for mentioning pre-litigation mediation, and I'm going to come back to that very quickly. But I want to catch on that the word you used there, Dotor. And we are all familiar with that word. But funnily enough, when we do go to a Dotor, I mean, when we do go to a doctor, we ask the doctor so many questions, right? Like so many questions. We'll ask, how long is this going to take till I get better again? How much is this going to cost me? What are the different medicines I'm going to take? Am I the only one who has this disease? You probably have multiple questions for your doctor. Unfortunately, when we go to our lawyers, we don't have enough questions for them. And I want to stress this very, very clearly. There is a huge role for the lawyer in mediation. Lawyers play a massive role in the mediation. And one of the reasons why mediation is not working is because people have entrusted their lawyer to make the right decision for them. And so lawyers now have a role, and I did an entire TEDx talk on this where I spoke about the multi-door dispute resolution system. Lawyers have a responsibility to introduce to their clients all the different platforms that are available for them to sort this out, whether it's arbitration, mediation, conciliation, negotiation. You don't even have to find a neutral party. You don't even have to find an arbitrator, mediator, or conciliator. You can see, and I know a lot of lawyers are already doing this. I'm not being naive here. I'm saying that it is a responsibility for every lawyer to introduce every different platform to their client. And it's also, today we are living in the 21st century, okay? every client, every person who is in a dispute should be going and asking the lawyers questions. How long is this going to take if I go down the litigation path? Will I get everything I'm really demanding? How much is it going to cost me? Right? A question that we once again don't really think about. Right? And finally, say I win the case. Is that the end? Is that closure? Is that finality? And every good lawyer will tell you that it's not. The other person has the magical button called the appeal button. And the moment the other person presses the appeal button, you're back in court. And so once you have thought about all this, you've thought about, okay, this is going to take me this much time, this is going to cost me this much, I might not get everything. Justice Brito or Judge Desmond might pass the order in my favor, but I might not get what I really want. I might get less than that. Am I happy with that? Right? And of course, during your times as judges, now you're all mediators and arbitrators. But and then the question once again is not posed. We don't ask ourselves this question: is our mental health? What does it mean to be fighting a court case, a family dispute, or a property dispute in court for the next 10 to 12 years? What does it mean? I've been part of mediations where you had 5 or 6 siblings who've been fighting court cases against each other. Of course, big family mediations where where they had property worth crores of rupees. 6 siblings fighting cases against each other, multiple cases filed against each other in different parts of India. Cousins who were teenagers now, who had not met each other ever, just because their parents were fighting court disputes. Cousins, can you imagine that? And I'm not making this up. These are true stories. These kind of cases getting resolved in mediation within 48 to 60 hours. And it's tremendous when you see the entire, catharsis taking place. And that's where I'm also coming back to another point. I think our goal here, and of course, Justice Brito and Judge Desmond are going to be part of, our team of advisors who will try and put together this center soon. And the goal is not just to mediate and resolve a dispute, but also to try and facilitate a reconciliation, where there is more than just solving the dispute. There's more about repairing relationships and moving forward. And on that note, just another quick question to my guest is, people always believe that when they, and of course, from your lens as judges, people also always believe that they will achieve justice, the word justice, when they go to court. But there's always this one disgruntled party, right, who loses the case. And then they'll always either say that the lawyer was not good or the judge was biased. And sometimes even the person who has won the case is upset about the fact that they didn't finally get the right deal. So what, according to you, is a true pursuit of justice in your opinion? Considering that many times a conclusion of a court case doesn't necessarily bring peace, closure, and happiness. You can be even the winning party, but you might still not get peace and happiness. So how would you define justice in today's world, knowing what we have available to us? Justice Brito, you would like to?
Yes. Yeah.
I think you muted yourself again by mistake.
Yeah, I'm back. At the end of the day, justice is what you get from the court. It will not satisfy both the parties.
Right.
Okay, one point I want to make there. Second point I want to make is that a few lawyers are not at all supportive of these settlements, whether it is by conciliation or this. I used to do a lot of conciliation work. I have heard with my ears the lawyer telling the client, "Tu settle kar jalya kar, aana." You follow? "Tu settle kar jalya kar, aana." Now, in such a situation, the client is not agreeing for any settlement. He goes along with the lawyer. And you remember the old story. The son became a lawyer. The father was not well one day. So he sent the son. Son settled the case and came home and told, "Dad, I have settled this case." He said, "Son, what have you done?" So this is a case, he says, "I built a house, I got a car, I paid for your education, and you are telling me you settled the case." This is how our system works.
Thank you for sharing that. I think there is, I have always advocated for the fact that lawyers are the gatekeepers to resolving disputes to mediation. They are the gatekeepers. And that's a very, very great example, very good example you have mentioned about the lawyers saying that you want to settle it, you settle it, but I can't help you there. And my advice to anyone watching today is, if your lawyer is washing you out and saying, I'm not going to accompany you in a settlement process, change your lawyer. There are trained, certified lawyers who understand negotiation, who understand mediation, who understand conciliation, who understand arbitration. They understand, they're trained, they're certified, they are skilled. Find that lawyer, because your lawyer is outdated, obviously, right? So I'm not saying that every lawyer is bad, and I don't think anyone on the panel is saying that. We are saying find a lawyer who understands every role and he can represent you in every role, and who's ready to say, listen, let's try out mediation for a few hours. Let's sit down. We have a trained mediator. Let's sit down, invest in it in 3-4 hours, 5 hours. If it's not working out, we can always come back to litigation. So the point, once again, making it very clear that just because you tried mediation does not mean that you can't try litigation. And if someone's telling you that, that's a lie. You can try litigation at any point of time. That's your right. You have a right to litigate at any point of time. So so I think the main point is find lawyers who are skilled and knowledgeable, and not who are giving you outdated advice from the 20th century. Another, I think, point I want to make because I think Judge Desmond brought this up a little earlier about pre-litigation mediation. And as your role as judges, you all might have referred a lot of parties to mediation, and that is court-referred mediation, where the judge who is sitting when looking at that case thinking, this is not suitable for litigation. This can be easily resolved. And so when that judge refers that case to a mediator or a mediation center, that's court-referred mediation. But what Judge Desmond was talking about earlier about pre-litigation mediation is basically you trying to mediate before even trying to file a suit or to file a case in court. And basically that's why it's called pre-litigation. So before you try and file a case in court, you either tell your lawyer or you yourself can reach out to the other side and say, hey, let's try and talk this out. But the other person will be like, no, I can't see your face because I don't even want to sit across the table with you. And that's where you can bring in this third neutral party, this trained mediator who can help you resolve this dispute. Now, quick question. Does mediation necessarily have to have both parties in the same room? Because a lot of parties come up to me and say, I can't even stand the other person's face. I'm not going to sit on the same table with the other side. And to that, my answer is no, you don't have to. You can have 2 different rooms where one party is sitting in one room, the other party is sitting in another room, and the mediator will shuttle between both rooms and try and bring you all to a common ground. And funnily enough, towards the end of the mediation, many times one party will be say, you know what, we're about to settle now. I don't mind going and sitting on the same table. And that's once again a catharsis that happens. And I know this sounds very idealistic, but we have seen this happen, and I know all of us on the panel have seen this happen. I want to pick up a couple of questions that are there in the chat box, and I'll shoot one across to Judge Desmond straight away. Can 2 parties be recommended? Judge Desmond, you'll have to just mute yourself for a second. Can 2 parties be recommended to go to mediation at the early stage of a dispute, or is there an appropriate timing when parties could be ready to have a face-to-face discussion? Is one of the questions that we have. Is there an appropriate timing during a court proceeding, or can it be recommended anytime? That's the question.
Yeah, actually, what they say that there's time and tide waits for no man, we say. But at the same time, there's time for everything. So actually, the concept which you are developing of pre-litigation is one of the modern jurisprudence is emphasizing on that, because everybody knows, means that the backlog of cases, the huge delays in disposal of cases, the long drawn-out battles that take place in courts. That is why, if parties arrive at a settlement when they are at an earlier stage, it is always more advantageous. And there's no there's not that parties cannot refer to mediation at the outset. In fact, it is always it would be a very welcome stage, because you can say at that stage, parties' angers is, or say like parties' differences may not be so difficult to sort out. And people know, like in modern times with social network and with the vast development of the network of internet and everything, like people know, like means people themselves find out like how long cases last, what is the kind of what is the law in this respect, and that is like means people are more educated. In fact, that is what I think is very essential, and I think this Zoom meeting today also is part of the whole process where we have to spread the consciousness. What we say that we have to create more and more awareness of how people can come together, how we can resolve our disputes. Well, that must be the essence of the and there's no as your question is basically like whether there's a stage. There's no, the earlier the better, as we say, like always. But at the same time, better late than never. Even if parties have been fighting in courts for long years and they find that the case is not progressing, dates are being given, long adjournments. In fact, like we see that in Goa today, the property disputes between Munkars and landlords. Unfortunately, like the Mamladar courts just keep on giving dates. Deputy collectors keep on giving dates, because I'm not singling them out, but the greater litigations in Goa, especially if you see inventory proceedings, for example, family disputes are basically about the division of the estate. We have inventory cases of 1953 still pending in the courts. Very unfortunate. So I think that mediation should be at any stage, and mediation should always has a very important role to play, because mediators are today trained. Mediators have undergone advanced training and scientific tools are used, and that is why I would strongly recommend, in fact, if parties approach the mediation centers. In courts also we have got mediators, and now a lot of mediations are taking place all over. I think that's a very useful tool to reduce the pendency of cases in the courts.
That's a very strong point. Thank you, Judge.
Can I come in?
Yes, sir.
I think for an experienced judge, the moment he reads the plaint, he should know more or less what sort of case it is. And the moment the defendant is summoned, that would be the ideal time to make a suggestion for mediation or conciliation, whatever it is. Because if you wait till the time the WS is filed, now WS is filed with a lot of mirchi masala, and then positions become little difficult. So the ideal time would be before the defendant files his written statement.
Yeah,
Ideal time.
I was about to expand WS for the crowd. Yes, I think that's it's. But once again, Justice Brito, we are saying let's take a step even before that.
Yes.
Let's take a step much before that, where you and your lawyer can decide, hey, let's try and sort this out amicably. Let's find a suitable certified mediator. And what are you looking for in the mediator? Now, here's another really great point about mediation: the neutrality. A mediator does not take sides. A mediator does not pass a judgment. A mediator does not pass an award. The mediator is basically someone who's going to use communication tools, negotiation tools, and help you come out with your own solution. How do you identify this mediator? And here's where, once again, mediation scores over litigation. You cannot choose your judge. You cannot go and do, at the most you can do a background search about who he is and where he lives and whatever it is, but that also you will not have much time to do it. Lucky you if your lawyer even tells you who your judge is presiding over that matter. But you have no idea about who your judge is. The beauty about mediation is you can have a chat with your mediator and say, I want to get to know you before you try and mediate my case. Let's talk for 15 minutes. Let's meet at the cafe. Let's sit down and decide, I want to see whether you are capable enough of handling my family dispute that has been going on for 40 years. Do you have the skills? Do you have the knowledge? Do you have the temperament? Do you have the patience? And can you really be of value to me? And do I like your personality? And you can check all these things in a mediator and say, that's it, I'm engaging this mediator. And so that's once again, the neutrality aspect of mediation once again is a huge plus point where parties get to choose their mediator. Now, in court-referred mediations, of course, the court will send you to a mediation center. And of course, we are hoping and assuming that all the mediators in the mediation center are well-trained. But say your mediator is not doing a good job, you can always change your mediator. That's the beauty of the process. You are always in control of the participation and the outcome of the mediation. Remember, the outcome is always in your hands. No one can ever force you to settle. So thank you once again for putting out those really good questions, and thank you for those amazing answers. Let me see. There are a few really encouraging comments that have come onto the YouTube live chat, but I don't see any questions as such over there. There's a comment that's come in that from Lutz Baptista, who says this is very much a needed initiative. It's heartbreaking to see senior citizens spending most of their retirement days in court fighting cases which they should not be doing. Any quick comments on that from my guest today? Justice Brito?
The solutions are there. Go for mediation, conciliation.
Absolutely.
Okay, the senior citizens, as per High Court circulars, are to be given preference. Do the judges give them? When I was in the High Court, that itself had become a big queue.
Right.
Of senior citizens.
Yeah, and it's very discouraging to even see that happen.
But it happens. What can you do?
One of my inspirations to get into the mediation field was, and I've already spoken about this before, but was to see a man who was fighting a court case which was 28 to 30 years long. Probably it was more than, I forgot the exact numbers. And it was about a wall that was built apparently illegally, 100-meter or 200-meter wall. He was fighting a case in court for almost 3 decades, and it was miserable to even hear that story from him. Judge Desmond, any quick points on that before we have another question? Very important question coming up.
You can proceed later.
All right. So a very interesting question, a very important question is, when two parties at the end of the mediation reach an agreement or a settlement, is there a written agreement done in mediation setting? Good question. Absolutely, it is done. And that's a lot of people will say mediation is not binding. You'll have people who will say it's not of no use. It's just a simple contract. It's just a simple agreement. There is a way to make it binding. There is a way to make it enforceable. And that is, you start it as a conciliation. You can talk to your lawyer, tell your lawyer, let's go and start a conciliation. Let's get a conciliator. There's a very fine difference between mediation and conciliation. We don't have much time for that. But a conciliator is basically a little bit more proactive than a mediator. A conciliator gives solutions, advises, sometimes even offers the solution and say, I think what's best for both of you is this. Do you agree? Do you agree? And that's what a conciliator would do. One step further than a mediator, a bit more proactive. And so you can start your process as a conciliation and end it as a conciliation, right? And that settlement becomes a conciliator's settlement agreement, which is enforceable in the court of law. So in case one party changes his mind or her mind tomorrow morning, all you need to do is go to court and enforce it. It's like a court decree.
Jonathan, that is what you and I were taught.
I know there's a practical angle to it. Yes, go ahead.
So when we learn mediation, okay, but our act does not make any difference between conciliation and mediation. Okay, right. And that whenever parties come together, what we did is we send them before the Lok Adalat. Mm-hmm. There they would sign the terms, and that would be a binding contract between them, a decision which could be enforced. That is what we did. Whenever the parties came together, we sent them on permanent Lok Adalat, and there they signed, and that becomes a decree of the court.
Yeah, that's a very good point, Justice Pedro, but you're also talking of this is a case that has already come to court. Yes. I was referring more from a private mediation. Before you go to court, then it can be done through a conciliator settlement agreement.
See, as I have already told you, we had that conciliation center. Yeah. People came even before filing the cases. Right. And if they agreed, they send the parties before the permanent Lok Adalat. Mm-hmm. And there it was settled. They got a decree.
Right. So, question to Judge Desmond is, what do parties do then? Say there's one party who now, of course, has watched this and is really inspired to try and settle something, but say he or she does not have an encouraging lawyer, or maybe he or she does have an encouraging lawyer, but the other side is not willing. can the lawyer approach the judge during a court hearing and say, I would, it would be nice if you can refer this to mediation? Of course, what is the procedure for a lawyer or for the party? Say it's a self-representation case. Can you approach the judge and say, I would like to try mediation? Can you refer this to mediation?
There is a provision which Justice Brito referred to. Section 89 was brought into the Civil Procedure Code. Basically, for that, the court, whenever the court feels that a settlement is possible, the court shall refer it to. All these are the four lok adalats, arbitration, conciliation, or mediation. These are the four methods or remedies which are provided in the CPC. So always, even during the course of even when evidence starts, even at that stage, one of the advocates can always say that please refer it to mediation or refer it to conciliation. In fact, many of the cases in the courts are resolved through lok adalats, which are held very regularly. In fact, we have national lok adalats conducted by the National Legal Services Authority all over the country on the same day and same time. Like means huge thousands and lakhs of cases also get settled sometimes in lok adalats. So it can, as we said earlier, it can be at any stage, and an advocate can always approach a judge saying that please refer the parties for the settlement.
Thank you so much for elaborately putting that. So one final question to both my guests before we wrap up is, from on a very personal note, I'm sure you'll have dealt with so many cases and so many people who have come to know you as someone who has delivered that justice to them. And I'm sure that you've also gone out of your way to try and sort things out, wherever you found like there was a case that could have been just settled, you facilitated that settlement, you pushed them towards to try and sort this out amicably, try and sort this out through dialogue, maybe not the word mediation, but even sort this out by themselves without dragging this case to court. What's the, just to put you on the spot here, but what's the best compliment you have received, or what, one of the, maybe a memory that you have in mind of someone coming back to you and saying, thank you so much for doing this, because if you had not done it, we would have been in court for years. And anything that comes to your mind, any such, without taking names, of course, we have to maintain confidentiality, but any such instance that stays with you till today of someone coming up to you and saying that, thank you for doing this.
No, judges always remain aloof.
I know that you remain aloof, not every other judge. Today, judges are very popular. Justice Brito.
Yes, I know that. Times have changed.
Times have changed.
The WhatsApp and the what is that Facebook. We did not know what was the phone. We did not know what was the phone. I said when we started our career.
I was just mentioning to someone that it's very difficult to find any information about you online because you have stayed away from the spotlight. Of course, judgment was more popular during his days.
Read the article by this Rainbow Warriors.
Okay.
By one Menezes on this Herald Sunday, I think. If you want, I will send a link to you.
We shall share that with all the participants who has joined us on Zoom. But
Rainbow Warriors. All
right, we'll do that. So that's a very clear endorsement about what Justice Brito feels like. Judge Desmond, any closing?
No, somebody remembered me after 11, 12 years of my retirement. That is what I'm trying to tell.
All right, okay, fine. Judge Desmond, any closing?
Yeah, no, what happens is like what we say is like when we sit in courts, like we try to decide cases, as I mentioned earlier, blindfolded. Justice is blindfolded. When you enter a court hall, you generally see a woman handling the scales of justice, and like means justice is to be given without bias, without any consideration other than as per the record, like, and finding out what is the truth, separating the truth from the falsehood, and giving the judgment. In fact, my experience was that. Just a few days back, I met when I was in the fruit buying fruits in the market. One of the persons came up to me and said, "Doctor, orkana maka." I said, "No. I said, "No. You convicted me, saying for life sentence you gave me murder, and thereafter, but now I am out on parole." He's saying. So after some days, when I went again to the food market, I said, "Brother, the danger." I said, no. There is a confidence like this. He was convicted by me on a murder case. He's now ordered parole and he meets me and invited me for his wedding also. So that is the way it is like. Means that when we give judgments, we are satisfied that, okay, you've done what is right. Maybe a high court may set it aside or a higher court may convert an acquittal into a conviction or a conviction into an acquittal. But ultimately, like you have to decide as per your conscience and as per the settled principles of law. That is where your confidence of the society grows in the judiciary and in the judicial system. And I think that mediation has a very big role to play in bringing about more balance and more peace in the society.
Thank you for seeing the bright side of that. Could have been quite an awkward moment, but I think to wrap this up, we're all on the same page here about we are not trying to substitute the courts. We can't, because we need the courts to take care of certain cases that cannot be mediated. This is not an alternate to court. I don't like the word alternate dispute resolution. This is a whole different process. I think Justice Pedro said earlier on about the ambassador car. This is not an alternate to the ambassador car. This is its own brand. It's its own process. It's about collaborating together, finding the solutions together, moving on beyond who's right and wrong. It's voluntary, it's confidential, it's neutral. And at the end of the day, it's a process where you find your own solutions with the help of a certified, trained, skilled mediator. They are out there. You will know more about them. As I said, the Nirmala Institute of Education and Pedro Arroyo Institute are both joining hands to come out with a center very, very soon. You will hear more from Judge Desmond and Justice Brito and myself. And stay tuned to future webinars on mediation. Thank you so much for joining us on a very busy Tuesday evening. Good evening. And thank you so much, Judge Desmond and Justice Brito.
Thank you.
All right, we can wrap up the recording.
Oh, Jonathan.
We can, 1 second, can we stop the live stream? Yeah, let's see if we can just stop the live stream.